Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. You can access more information from our news in document by clicking on the icon in the top right hand corner of the screen. A recent case between the SFO and ENRC has given a chilling warning about the limitations of legal privilege. In this case, ENRC's law firm undertook a compliance investigation including 85 interviews with employees and some third parties. The SFO sought disclosure of the interview notes, but ENRC refused, claiming legal privilege. The High Court determined that the documents were not privileged because the interviewees were not the law firm's clients, it was a data gathering exercise and not legal advice, and at the time there was not a real likelihood of litigation. The contra proferentem rule provides that any ambiguity in a contract should be resolved against the party that relies on it. However, in a recent case, the court commented that for commercial contracts negotiated between businesses of equal bargaining power, it has a very limited role. This continues the general trend that courts are reluctant to interfere with the words written in a contract. The new pre-action protocol for debt claims will be effective from October 2017. This makes some changes to the way debt claims should be managed before court proceedings, including extending the time limit for a debtor to respond from 14 days to 30 days. The protocol applies to any creditor businesses recovering a debt from an individual or sole trader unless the matter is covered by another pre-action protocol. The Digital Economy Act was effective on the 27th of June. It's a hodgepodge of changes including permitting the sharing of some information between public authorities and obligating the ICO to publish a statutory code on direct marketing. We understand that the ICO will consult on its existing guidance on direct marketing. The European Commission's Data Protection Working Group has now published draft guidance on data protection impact assessments, DPIAs, and has approved the final version of guidelines on data protection officers and data portability. Here's our quick summary. DPIAs are required where processing is likely to result in high risks to the rights of individuals, e.g. automated data processing. The guidance recommends where appropriate that there is consultation with individuals and that the businesses publish their DPIAs. DPOs must be appointed for public authorities and any organisation whose core activities require large-scale processing of sensitive personal data or regularly and systematic monitoring of individuals. Systematic monitoring includes data-driven marketing and using data from connected devices such as home automation. DPOs should not be subject to any conflicts of interest. Data portability is a right for individuals to require a data controller to port certain data to a different third-party provider in a machine-readable format. It applies to personal data processed using automated means where processing is carried out either based on consent or that it is necessary for the performance of a contract. Whilst the GDPR states that the right of data portability applies only to personal data provided to a controller, the guidance interprets this broadly. The pensions regulator is making spot checks on auto-enrolment compliance. Penalties have been issued where companies have failed to comply with its information gathering powers. Johnson's Shoes Company has been issued with a £40,000 penalty. In the case of Capita v Darge, Capita sought to restrict some former employees from establishing a competitor business and require them to produce emails that have been sent from Capita accounts to personal accounts. The High Court refused Capita's request because emails sent to personal accounts were not automatically the property of Capita. The non-solicitation clauses were unenforceable as they sought to cover customers who the employees had become aware of rather than customers who the employees had personal and material dealings. In Beat v Croydon NHS Trust, the Court of Appeal ruled that it is for the tribunal to decide whether an employee is protected by whistleblowing laws, and the employer's belief is irrelevant. A tribunal has ruled that an employee has a right to be accompanied by his or her choice of representative, even where the employer had strong reasons for refusing the representative. The only restriction is that the person is a certified trade union official or a colleague. It's understood that many big brands, including Tesco's and John Lewis, have made technical errors for calculating minimum wage claims. John Lewis has set aside £36 million to settle claims that arose because of its pay averaging scheme. Tesco's technical failures arose due to payments made for pensions, childcare and cycle to work schemes. We have previously reported on the first opt-out class action. This was a civil claim following the OFT's successful action against Pride and 8 of its retailers for competition law breaches in 2014. This action has now been withdrawn because the costs outweighed the benefits. The estimated value of the claim had been dramatically reduced after the tribunal ruled that the claim could only be for customers that had purchased from the relevant retailers and not all retailers. Thank you for tuning in to this month's commercial bulletin. Please feel free to contact me or my colleagues at LexisNexis about any of the stories we have covered. We'll be back next month with another update.